Hello to all our new friends. I hope everybody had a good chance, whether you're online or in person, to slow down, process some information, ingest some sustenance, and get ready for a brand new afternoon of learning. We're so glad to have you here for our next session of the AI Bootcamp entitled What You Don't Know Can Hurt You, AI and Evolving Regulations. So this session is really about the shifting legal and regulatory landscape for AI in healthcare and the risks that come from both using and potentially from not using AI tools. To help guide us through these complex topics, we've got two experts. Both of them bring deep legal and policy experience to the conversation. They're both JDs, so we've got some credentials in the house, which is very nice. And then I'm going to do a quick introduction for them both, and then we'll get on to the content. First, we're joined by Alia Suleiman, who is leads compliance, privacy, and regulatory affairs at Datavant. Alia is a nationally recognized expert on evolving regulatory landscape around data interoperability and AI in healthcare. Before she was at Datavant, she was a partner at McDermott, William, and Emery, and previously served in regulatory leadership roles at Epic and Manifest Medex. She brings a deep understanding of both the legal and technical realities of AI development in healthcare. And we're also joined by Sylvia Trujillo, who is currently who is the executive director of the California Telehealth Resource Center. I just slipped and said currently because we were all wondering about our funding for a second there, but we're all good. We're all good. Sylvia has spent over 2 decades shaping policy to support the adoption of digital health and create AI-enabled tools or have AI-enabled tools across public and private systems. She has experience at the National Regulatory Strategy with Medicaid reimbursement and provider enablement, and from her leadership at a major health IT organization to her prior work at the American Medical Association. And we are going to get some great perspectives today. They're going to help us unpack what is really a rapidly moving AI regulation and liability landscape. So with that, I'm going to turn it over to our speakers.
Okay, hopefully everyone can hear me. Great.
A little closer.
A little bit closer. Does that work? Okay, great. So thank you all so much for joining us today. I have given sort of talks about the regulatory landscape for healthcare AI in particular so many times over the last, 2-3 years. Where we stand today as a country in the state of California is a really different place than we've been in the past. And I say that because we've got a brand new federal AI action plan and some AI executive orders that take a really different approach to just AI regulation in this country. With that said, I think we could, I can click here. Oh, sure. Yeah. Oh, okay. Yeah. Okay. All right, so no conflicts of interest. Okay, so the race to regulate. So just as tech companies are racing to develop the leading foundation model, we have seen over the last few years, regulators of all shapes and sizes and jurisdictional overviews racing to develop a rubric for how we judge whether AI is safe, appropriate, fair to use in a particular context. So the squares on this slide represent different layers of oversight that we've seen crop up at the federal, at the state level. And I wanted to call out a couple examples here that sometimes fly under the radar. So number one, when my company at Datavant, we operate in an environment where state laws really matter. So we have an entire team that is dedicated to tracking state legislative policy proposals, bills, sub-regulatory guidance that comes from state health agencies. And what I can tell you is that there has been an over 450% increase in the number of those policies and proposals that describe, touch, or relate to health AI between 2024 and 2025. Some of our legislative sessions are still active, so we'll see if that number increases. All that goes to say that it is clear that states are a hotbed of regulatory and kind of policymaking activity around AI generally, but health AI in particular. And I'll talk a little bit about state law examples of really their approaches to regulating AI, specifically in the healthcare context, a little later on. With that said, there are also sub-regulatory sort of industry association guidances that are also impacting the state law landscape. So, a couple examples. In the health insurance space, the National Association of Insurance Commissioners issued a model bulletin on AI, and that has been adopted by insurance commissioners in 24 jurisdictions and really sets expectations that apply across the insurance industry, but with, that typically applies to health insurers as well, around the responsible use, measurement, and overall, oversight of AI when used in consequential decisions. And that is a buzzword that this group should remember, because there is a tendency in health AI policy and regulatory kind of rulemaking to focus on AI that is high impact or high risk, and consequential decision making is typically the buzzword that's used to differentiate that high risk, high impact AI from other low risk administrative use cases. With that said, we'll talk a little bit about an example of federal rulemaking that doesn't care whether your AI is high risk, low risk, administrative, or clinical. It applies, requirements around transparency, risk management, and governance nonetheless. But on the flip side of, I talked about the National Association of Insurance Commissioners. There's also the Federation of State Medical Boards. Some of you may be familiar that the Federation of State Medical Boards issued a report in 2024 outlining recommendations for how state medical boards should think about responsible AI in the context of the physicians and clinicians that they license and oversee. And we know that at least one state, the state of Washington, has adopted those recommendations in some form as a part of their medical board kind of oversight procedures. And it is likely to be a key part of future state medical board considerations. And we're seeing state laws give enforcement authority in some cases to state medical and osteopathic boards when it comes to, who has the actual, permission to enforce fines or create consequences for noncompliance. And then the last thing I just wanted to mention is the executive branch sort of executive orders, the federal policy here. The 25-page AI action plan, the 3 executive orders that came out in July, the key theme there is bolster American AI dominance through deregulation. So I think that we are going to see either a softening or in some cases a rescission of federal frameworks in this space, potentially around health AI as well, just given the direction that we're seeing from the federal government. So these slides are going to be available, so I won't spend a ton of time talking about the details on each slide, but I wanted to just showcase an example of, this is a federal AI law that applies to a developer of particular AI-enabled technology. So this is a law that was passed back in, 2023, I believe, yes. And with a compliance date, 2024 with a compliance proposed in 2023, finalized in 2024 with an effective compliance date of the end of 2024. And this law applies to AI that's embedded within certified health IT systems. So EHR systems that are actually have gone through the federal certification program such that they can be used for, as a part of Medicare programs, really. And this is one of those laws that doesn't care whether whether the AI embedded or made available in a system is being used for administrative or clinical purposes. It really focuses on the functionality. Is it supporting decision making? Is it based on algorithms? Is it that are trained on training data? And is it producing an output that qualifies as a prediction, classification, recommendation, evaluation, or analysis? Those are some pretty broad nouns, right? So I think we've seen a lot of variable interpretations on how broad this rule could actually be. I've got another slide here that talks about some of the details of that requirement. A totally different example that applies to healthcare organizations is the Section 1557 final rule that really focuses on putting the onus for AI risk management and governance, as well as just ongoing monitoring and oversight on healthcare provider organizations that receive, federal funding. Really, anyone that qualifies as a covered entity, not in the HIPAA meaning, but in the Affordable Care Act meaning. And the key thing I want to highlight here is it applies to patient care decision support tools, which is, again, more clinically focused and administrative and has to have some impact on patient care. But the most interesting thing about this final rule was that it was actually pretty specific on the expectation that healthcare organizations, that the regulators have for healthcare organizations when it comes to assessing risks associated with these patient care decision support tools. These 5 items on the slide here are actual, content from the preamble of the final rule that outlines what healthcare organizations should be doing to assess the intended use, appropriate use, warnings, contraindications, other considerations that may impact the fairness, safety, efficacy, and reliability of these tools. And then what does that, so this is the interactive portion. Does anyone know what you get when you combine these 3 things? Any guesses? State law, that's what you get. So because of the vacuum at the federal level, we've seen, as I mentioned, a huge increase in state laws focused on AI. And I put just 3 examples here on the slide. Not going to go through all of these in details, but wanted to use them to highlight a few themes. So number 1, we see a focus on, again, AI use in consequential decision making. So that first California law focuses on AI in utilization management and emphasizes the importance of clinician involvement and making kind of an individualized determination about utilization management based on, the factors in someone's clinical record. Again, more applicable to health plans, payviders, right, than providers. The second California law, again, these are both effective as of this year too, so FYI. The second California law is about transparency. That is another key theme that we see in some state legislation. If you're using AI to inform a patient interaction, does the patient know? Might that change how they rely on the output that they are receiving in that interaction? And while the law doesn't take a position on what is an appropriate disclaimer, it certainly indicates when you should have one. And then the final law here, I just think is interesting because it imposes requirements on the use of AI in quote unquote regulated occupations in the state of Utah. What does that mean? That means over 30 different healthcare professions are technically regulated by the Utah law. That is another theme we are seeing, this emphasis on heightened controls for AI when used in regulated occupations. And we have seen a lot of state bills kind of copy and paste that concept from the Utah law into their proposals. And it's just notable because we're talking about impacts on physicians, surgeons, dentists, pharmacists, midwives, behavioral health therapists, you name it, anyone who is sort of licensed by the state. So lots of themes to track there, but I'll pass it on to Sylvia for the juicy stuff.
Well, I don't know if it's juicy, but so I'm going to jump up here. I'm a mover arounder. So I'm going to tether myself here, but I may move around a little bit. So I want to make sure I'm still in frame, but just very quickly, what I want to first emphasize is that we have this framework, and remember there's different applications of AI systems. There's research, there's operations, there's population health, and there's clinical applications, right? Those are 4 different ways you can apply AI systems. And depending on the methods and systems, conditions of deployment, levels of autonomy and functionality, they have varying levels of risk and potential for harm, right? So remember, what they're really trying to do here is address the potential for harm and to make sure that there's informed consent. So I'm going to try a different lens. There's the regulatory environment, and what Alia has laid out are compliance with a regulatory regime. But any clinicians in the room, remind me again, any practicing clinicians? Okay. So as practicing clinicians, you know that there's the compliance of the organization and your compliance as an individual, but you also have liability when there's patient harm. And so I have no conflicts to report. But we do have situations where AI systems have been deployed and harm to patients has occurred. I'm going to focus on one of them. So it's been talked about ad nauseum. Sorry for the folks that have heard this 50,000 times. But we, on your right-hand side, we had a situation where a company developed an AI tool that was designed to help reduce readmissions. And so it was supposed to help hospitals and clinicians and their care teams identify patients who are at high risk of readmissions and provide them a more intensive set of supports in home. It turns out that the design of the tool was wrong because instead of addressing acuity, it was really evaluating utilization. So they determined that patients who had been high utilizers of health services were higher acuity and that those were the same thing. And so those patients needed more intensive services. Well, that's a great correlation for whether or not you're insured or not. Utilization is a greater function, not necessarily of your acuity, it's a greater correlation of whether you're insured. And so it turned out disproportionately, as we all know, certain communities have lower insurance rates, and as a result, lower utilization. So why does this matter in the liability sense? Somebody figured it out. Some researchers came in and identified the issue. The organization said, yes, we'll address it. But then some investigations were opened up, including in Massachusetts. And the question is, who's liable for that algorithm? Because there were thousands and thousands of patients who did not receive the same level of service, the same level of care. And the immediate answer from the organization was, this was only assistive. The liable parties are the clinicians. And the clinicians said, absolutely not. We did not utilize these tools. The care teams that prepared their discharge prepared it, and in some cases didn't even know about it. So it turns out we have some intersections between liability and regulatory compliance. And so when you think about liability, you have, is it the clinician, is it the health system, or is it the vendor developer? I think most people here today are most interested in, am I the clinician or I the provider liable when there's a bad outcome or a patient is harmed? And so we're not going to spend a lot of time here, but there are different flavors of liability. And a large number of clinicians, it will come as no surprise, are really interested in this professional liability question. So we're going to focus on that, but it's not unrelated to these other levels of liability that may go to other parties. So you may see liability that's shared liability across different entities when there's harm. And Alia touched on this. It's not just physicians. We're seeing all sort of flavor of clinicians that are relying on AI systems and utilizing them. And as she noted, the Federation of State Medical Boards and others have come out and they've said, if you're using these systems as an individual clinician, you are responsible for a duty of care and you are responsible for making sure that this is not going to equal harm. So what does this look like? So we're looking at traditional models of legal liability, med-mal, as many people know about it, medical malpractice. And there's several types of legal standards. One is strict liability and intentional harm or negligence. And we're really focused on negligence because the question is, did you exhibit the standard of care that was necessary to avoid harm? And so what we are now currently seeing is while states are developing new regulatory regimes that could change what the standard of care would look like in any given jurisdiction, they are using traditional standards. And typically, when you look at that, they are evaluating not only did the provider exhibit the standard of care, Was it a support tool or final decision maker? Remember, the very first example today was an autonomous AI system where the developer said, yeah, we're liable for the wrong outcome. So that's an important question to ask developers and vendors. If it's an autonomous AI system, then they should be holding the liability, and that should be part of the discussion. And also, here's this other very burdensome question. AI is supposed to reduce burden, right? Well, now we're starting to see a standard where you're being asked to document the reasoning for accepting or rejecting an AI recommendation. Can you imagine more documentation burden? So here the lawyers are creating like more burden where we're trying to get rid of it. So this is an evolving space as well. So basically, here are some of the questions you want to make sure, and this outlines some of the issues that Alia laid out as well. You want to go through each one of these items and identify whether or not there's someone in your organization, because you have the policies, the procedures, and the personnel who are comprehensively sitting down and tracking if your AI tool is coming into your organization, that you've gone through this checklist. Good news for the California folks, we do have some toolkits. You'll get that at the end of this process, and more will be coming for other participants across the nation. So this is what we've really come to understand, is that over time, there's still some gaps. They're still applying traditional standards of harm and causality. And so, frankly, the burden still remains on patient plaintiff litigants to establish that there was a causal relationship between your use of the AI system and their harm, or alternatively, the harm was proximately caused by your lack of use of AI. And quite frankly, as challenging as medical liability is and costly liability insurance, the reality is that these are claims that are still a very, very small percentage of overall services that have been provided. But it is something that you have to keep in mind. I'm not going to go through the state laws. Alia called those out. I just want to finish really with us focusing on the key takeaways. So when you're using AI, you cannot go on autopilot. So lots of studies show that we are a bit a technology chauvinist, that we tend to want to rely more on a machine's output than we would rely on an expert colleague's decision making. So we have to really combat around our desire to default to rely on machine output or AI systems. The idea of why you didn't follow an AI tool's decision output. This is something you need to think about in terms of your policies and procedures. And I don't know that we've arrived at that state yet. Alia, that might be a great question for you to answer. But really fundamentally, you should be asking, and we do have a vendor checklist that we'll have available for you all at the end of this. You need to ask really basic questions around the validation and training data and whether it's appropriate for your patient population and your conditions of deployment, and several other key questions. And then to Alia's point, every single one of the states of the folks across the nation who are online, there are bills in your state on AI in general, and certainly those that touched on AI. And if you're here in California, we have a chock full, and we'll be reporting out on that. So once again, responsible use really is what protects you more than avoidance, and that's important to remember. So
now we are going to move into some Q&A time. We've got two questions kind of preceded from some of our other speakers, and I'll go ahead and just read those out, but then we will be taking questions from the chat and then from in-room as well. So we just kind of prep yourself. If you've got questions, get those lined up, get those in your head. Our first question comes from Dr. Chandra, who we heard from earlier today. And he asks, given the black box nature of many AI models in healthcare, how can regulatory frameworks ensure that clinicians and patients can trust and verify AI-driven decisions without compromising proprietary algorithms?
I'm happy to take this one. So I think the key thing that is sort of has to be the driver of any AI deployment or implementation or work with a particular vendor is having a really crisp definition of what is the problem we are trying to solve with this tool, and ensuring that you are fully aligned with your partners, whether that's the vendor that may have developed the tool or your deployment partners internally within your organization, that we are all aligned on the problem to solve and that this tool is appropriate to do so. That's step one. Step two is that between some of the sub-regulatory guidance that's come out, also that ONC ASTP predictive decision support intervention framework, there's general alignment on key information about intended use, sort of training data, sort of the underlying kind of functionality of a model, performance and accuracy measures that the industry and regulators in some cases have already coalesced around as kind of core information to know about a model before you make a decision on how and where and how broadly to deploy something. So one of the great things that someone in this room has helped develop is a nutritional facts label for Health AI. There are some great examples of how that nutritional facts label can actually be adapted to address some of the performance feedback configuration options and sort of transparency requirements in that federal predictive decision support intervention framework. So that's a great example of hey, vendor, can you fill this out? Because there's a lot of information you can glean from that level of summary that doesn't trip into, okay, now we're getting into proprietary IP that the vendor isn't comfortable sharing with you. Even for administrative models, and I've implemented this at my own company, a lot of the AI we deploy is truly like administrative in nature. So one of the services we provide is supporting the release of information function, and a combination of a trained LLM plus optical character recognition models is super helpful for interpreting a faxed record request and mapping data elements to a field in our automated fulfillment system so that it could then be processed digitally through APIs. It is a very low risk model, right? Like it is a low risk use case that is about automating an administrative workflow, but we've still been able to work with our software engineering and data science teams to do a lightweight nutritional facts label that focuses on things like model functionality, the types of documents and request types that the model was trained on, performance and accuracy measures, and we refresh that on an ongoing basis. So I think that is like really a baseline expectation at this point that any vendor or developer operating in the space should be able to articulate to you without, tripping over that, well, you're asking for my IP kind of counter argument.
So I'm not going to disagree, but I want to make sure we're all in the same place. How many folks are familiar with this concept of a nutritional label for AI tools? Okay. So everyone in here is familiar with the nutritional labels for food. So I want you to imagine that in your head. Now, that's standardized disclosures of things like protein level, carbohydrate, sugars,
total fats.
Yeah, sodium, right? It's all standard, it's all the same, and it's across all foods. Now, imagine this same type of label for AI tools with elements that distills key pieces of information that help you decide whether or not you and your staff and your patient should be consuming that tool. It may actually lack nutritional value for your patient population, your team, because the data developed to train the tool was not data representative of your patient population. And there's a host of other factors that are disclosed within that nutritional tool. And we're going to have the folks that created that tool as our last panelists who can touch upon this. And it has been widely cited by federal regulators, and it is referenced by my organization and many others as essentially something we need to normalize and distribute. And in fact, is the bare minimum that your vendor should be sharing with you. And if they do not, that is an opportunity for you to say, this looks like AI snake oil, and we're just gonna keep it going. Okay.
No, great responses. We're going to ask, Dr. Sendek, who we'll be hearing from later today, asked a question. And his question is, when AI tools contribute to a clinical error, how should responsibility be assigned among the clinician, healthcare institution, AI developer, and what legal or regulatory guidance should define this accountability?
Happy to start, and we'll pass it on to you, Sylvia. But the reality is that a lot of this is handled contractually. That is the reality. So for anyone who has a contract with an electronic health record company, you will likely be familiar with concepts that, essentially say that you're being licensed software, but that ultimate configuration, decisions, deployment, and overall training and use of the tool pursuant to clinical and professional judgment sort of rests with you. Sylvia mentioned some theories of liability, like products liability that, have been playing out in courts for years. But the reality is that establishing standing to actually hold software developers, SaaS companies accountable, has not been very common. And part of the challenge is that products liability frameworks were intended to deal with products like a defective seatbelt, or you find a nail in your can of tuna, right? Not software, which has typically been considered more of a service in the kind of litigation to date. So with all that said, the contractual terms will typically spell out like who's actually liable for that error. It is most likely going to be a healthcare organization, and there are types of insurance now and riders for insurance policies I've seen in the cyber liability space that are evolving to account for AI related risks. So it is worth, if you are involved at all or simply curious about your organization's insurance profile, it is worth asking whether AI related questions are cropping up when renewal time comes along, because that is definitely a trend that I've seen. So it's a risk. The liability definitely sits more with the deploying organization and clinicians as a result, but it is an insurable risk, at least right now.
Yeah, so we're sort of switching. We went from regulatory compliance and traditional medical liability, and now we're flipping our answers, because I'm going to talk about not just, I thought that was fantastic because it does address organizational liability. And I think oftentimes establishing traditional medical liability still remains, for the people in this room, this is fairly good news. It's still very challenging. For patients, for all of us as patients, not such great news, and particularly for vulnerable patients. So what I would say is that along with the ability to contract, or the need to contract, liability distribution, as well as contracting and expanding on your insurance, you also need to make reasonable investments in workforce upskilling and training, because the failure to do so, that in itself can be liability, both in terms of contributing to more traditional medical liability and adverse events, because the tools are coming. They're embedded in EHRs. There are operational uses of AI systems that may not result in medical liability, but can create regulatory liability and compliance challenges. But one of the most important ways to mitigate your risk is doing what you're doing right now, which is bringing along as many individuals within your organization to understand the fundamentals and to have policies and procedures. As someone in the back mentioned, the first question you should ask whenever you're deploying these tools are, what are the policies, the procedures? And I have one more P in there: policies, procedures, and people. What upskilling and training have you ensured on a consistent basis? And that's where we're here to help. And that's actually going to be a great segue, potentially, if we're at time, to our next panel.
Yeah, can we get a time check real quick? 5 minutes? Okay,
Keep it going.
let's take a couple more questions. So I'd like to take just a couple questions here. We got one there from Dr. Sendek.
So I forgot that I submitted that question in the form, but this is something that's come up more recently that I found striking. So we're talking a lot with organizations right now about how they evaluate AI tools internally before implementing them into clinical workflows. And we were having a conversation with a very senior chief AI officer of a very large health system. And we were asking about retrospective validations, which in my experience at Duke was like always a default that we would start with, of let's run the algorithm on retrospective data, see how things worked. In this context, a lot of their AI implementations had been in the imaging realm. And in imaging, it turns out there's a very strong pushback against retrospective evaluation of algorithms because of professional liability if positive findings are found that were missed. And organizationally now, they generally don't endorse retrospective validations of algorithms because of this liability question. So they just want to move to prospective assessments, which like is counterintuitive, because you're like, so let's put future patients potentially in harm's way to CYA on like prior care delivered. So I mean, you're both lawyers, like tell me what's going on. Like how do we fix that?
So I think that the liability risk that you're highlighting is very real. And I have encountered very few organizations that on using identifiable data are comfortable doing that sort of retrospective analysis because of this question of you figure out that a mistake was made or something was missed. How do you report that from a patient safety perspective? So this is an area where I actually think that de-identified data is key and changes the risk profile for an organization when performing that sort of retrospective evaluation. Not a great answer again. If you're a patient whose image had a pixel that would be interpreted differently by an algorithm than a clinician, like again, so like this is my purely like legal answer, but the reality is that if you de-identify that data, you can use the expert determination method under HIPAA. You can retain data utility in many cases, including for images, without rendering that information identifiable. Use that for your retrospective analysis. It doesn't present the same risk of like, okay, I found something off. Do I have an obligation to intervene? Because the whole point of de-identification is that you have a very small risk or ability to map that data back to an identifiable human. So you get the benefit of the the performance indicators and accuracy data without creating that same issue. But that might not work for every model and every use case.
So I don't have anything to add to that, but I do have a question for our online participants. Please throw your answers into the question and answer, and for the folks here. Does the discussion of liability feel so daunting that it brings you up to think, I don't know if I want to do this? By a show of hands. Okay. So that's a surprisingly low number of people, because oftentimes, what's that? I think oftentimes the complexity of the both regulatory and medical liability issues can be a full stop for organizations. I don't know what our online responses are, but what I will say,
There's
There.
a lot of yeses, all caps, exclamation point.
Okay.
Would Be a
So,
good use for emojis too.
Yes.
so what I will say is remember why we're here. The reason we're here is that there are shrinking resources, there is growing demand, high rates of burnout, and the error rates in our medical system are one of the, if it's not the leading cause of death and harm, it's one of the leading causes. So with fewer people, because birth rates are leveling out and dropping in some places, with an aging population and medical knowledge being generated at a rate unprecedented in history. So a human actually could not synthesize all of the information that the time when clinicians can do that, I think it's like over a decade ago. Like the amount of knowledge generated every week is so high volume that even the most conscientious clinician could not absorb it and apply it to clinical practice responsibly. So if you feel super daunted, just remember these are powerful tools for good, but they also can be powerful tools for harm at scale. And so it's activities like this that can really mitigate risk and harm and drive tremendous opportunity. So to the folks online, just remember this is worth it. We just have to figure out how to do it. And there's going to be a lot of people with you to do that.